Good morning. Happy Wednesday. Happy hump day. Maybe good evening, good afternoon, whatever it is for you. You'll figure it out. So there's a couple things that I saw that are interesting. First of all, congratulations to Rogue Nation. He, with the magistrate in his case against officer, I think it was in Georgia, question mark. He won $1 nominal. The officer never appeared, never answered the complaint, so he got a default. And then the default judgment that he got was for $1 nominal damages. And it was confirmed. That judgment was confirmed by the district court judge. So, congratulations. Don't spend it all in one place, and don't spend it before you get it, because there is a huge difference between getting a judgment for money and actually getting the money. The money doesn't just magically appear once you got the judgment. You have to go out and collect it. And let's be honest, it's going to cost more than $1 to collect the judgment. So I hope Rogue Nation hasn't already partied and spent that dollar, because it's going to be, I wouldn't expect he'll ever see it. But the reason why he got only $1, even assuming that the courts found that there was in fact a violation by the officer of his civil rights, the reason why he got $1 is because Rogue Nation didn't prove his damages. And in every lawsuit, there's two things that you have to prove. You have to prove liability. You have to prove that they did something or didn't do something that they should have done, or shouldn't have done, depending on what the case may be. And then you have to prove damages. And I'd say 8 times out of 10, the easy thing to prove is that they did something wrong or didn't do something that they should have done, right? That's the easy thing to prove. And that's what people who aren't attorneys tend to concentrate on, proving that the person did a bad. The hard thing to prove, the thing that you're actually paying an attorney for most of the time, besides the procedural issues, but you're paying the attorney to establish the actual damages. How much this bad thing that happened to you because the defendant did something they shouldn't have done or didn't do something that they should have done, that's the hard thing to prove. So Rogue Nation was claiming emotional distress and, PTSD or whatever. But what he didn't do is he didn't get a doctor, a medical professional, to come in and testify, or a psychologist. They're not doctors, but they could testify to emotional damages. And he didn't get them to come in and establish this is how much he's paid. This is how much he'll pay in the future for future psychological treatment. And, this is how much it's affected his daily life and things like that. So that's the issue for Rogue Nation. And as a tie-in, that's the issue that Chili's going to face, even assuming that he can prove that the officers are liable, which is a huge hurdle for him. In Chili's Las Vegas case, he has no real damages. He's got maybe a couple $100 worth of damages. And he can't really establish more if the judge does what I'm assuming the judge is going to do and grants the defendant's motion in limine to exclude medical expert testimony and medical exhibits done by Chili, because he doesn't have a medical expert to actually testify about what they mean and what they did and blah, 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 right? Chili can't really testify about him because he's not an expert. He could show the picture of the bruise. But what does that establish? He was bruised. Okay. You need an expert to testify about medical stuff, just generally speaking. Like medical malpractice, you go nowhere without a medical expert. It is literally, you lose, period, if you don't have a medical expert testify about the doctor not meeting the standard of care and how much it damaged you and what it's going to cost for your recovery. You just lose. So Rogue Nation, because he's not an attorney, didn't know what the hell he was doing, has an excuse. I mean, I told him in Discord what he needed to do, and he still didn't do it. So, what are you going to do with that? You you can explain it to them, but you can't understand it for them. Chili, he's got an attorney, Michael Mee, who I guess does mostly criminal work, but has been an attorney for a long time and has probably done civil cases. And Mee should have understood it. So the only thing I could still think of is that they don't have anything. Like, it was just a bruise. Like, and they can't find a doctor or a medical expert to testify that it was more than just a bruise, which is odd considering that I can find a lot of whores out there, medical doctors who are experts, and they'll pretty much say anything that you want them to say. I literally wrote a declaration for a whore medical doctor. I put in all the medical terminology. I put in everything I wanted him to say, and he just signed it. I mean, there's whores out there. There are whores out there. So I'm shocked that Michael Mee couldn't find someone like that. Pivoting to the case that, what is his name? DEI? DMA, Denver Metro Audits, has against Frauditor Troll. There was a motion to strike filed by Randy for one of the causes of action alleged in Frauditor Troll's cross complaint. Now, I don't practice copyright law, and I don't really understand it, and I don't want to spend the time to understand it, so, I'm not really commenting about much. But Randy filed a motion to strike, or anti-slapp motion, which is based out of California law. Basically, so SLAP stands for Strategic Lawsuit Against Public Participation. And essentially, if you can prove that really what you're getting sued over is your participation in public discourse, and you can show that they're only trying to stop you from participating in public discourse about some public subject or something like that. I mean, I'm really boiling this down to the read the statute, but this is just a general broad thing, right? So then you can file an anti-slapp motion, which would, if the judge grants it, not only would that cause of action be stricken, but you would then be able to recover attorney's fees for your expenses in filing the anti-slapp motion. And the judge would grant it, most likely. Hashtag not all, but generally speaking, the judge is going to grant those attorney's fees, reasonable attorney's fees. Well, apparently, Frauditor Troll's really expensive defense attorney, boutique defense attorney, included a cause of action that was susceptible to an anti-slapp motion. And Randy filed an anti-slapp motion to strike that particular cause of action. And Frauditor Troll's attorney immediately voluntarily dismissed it and said, well, Randy didn't meet and confer with us as required by the local rules, so basically the anti-slapp motion should be considered to be moot, and we're voluntarily dismissing this, yada, 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 right? Well, assuming the judge buys that, great for Frauditor Troll, but that leads me to something that I do know about. I'm going to assume, I have no actual knowledge of this, I just want to be very clear, I'm going to assume that Frauditor Troll's attorney said, we're going to take a tough line with this guy, we're going to get him to settle, and so what we're going to do is we're going to put bargaining chips on the table, and we're going to counterclaim for all this stuff, and we're going to get him to sit down because they're going to think that they have some liability, and maybe they do have some, I don't know, I'm not commenting on that, but he's going to say they have some liability, and so what we're going to do is we're going to get him to sit down at the table, and we're going to negotiate this out. This is a settlement tool for bargaining. And so I'm going to include causes of action, all the causes of action I could think of, which is great for billing. But it makes you wonder. If you knowingly included a cause of action that was susceptible to an anti-slapp motion, not only are you billing your client for it, so your client had to pay for the time for you to come up with that cause of action and put it into the counterclaim, cross complaint, whatever. I always get it backwards. California calls it different than federal, and I always get the two mixed up. Anyway, but so not only is your client spending the money to have that put in, But then your client also is potentially exposed to the liability of having to not only pay you to defend it, but having to pay opposing counsel for having to bring an anti-slapp motion. So it makes me wonder why he did it for any reason other than to bill. So I've just seen it too many times with too many defense attorneys who talk their clients into spending money on bullshit with the underlying assertion that, oh, this is a bargaining chip, this is going to get us to the settlement table, and this is going to convince them to accept a lower amount or maybe walk away. And it doesn't usually work that way, but the defense attorney gets paid for it. So, you know, if you have a defense attorney in a lawsuit, you know, be aware of that. That attorney has, I'm not going to say it's a conflict of interest, but that attorney has an interest in generating billable hours. And it doesn't always align with your interest in getting out of, because remember, the defendant's interest is in getting out of that lawsuit, paying as little as possible. So, you know, I'm not saying there's a conflict of interest, but I am saying that you need to be aware of it. And if your attorney gives you like vague statements like, I'm comfortable with this, well, that's great that you're comfortable with this, but give me some analysis. Oh, the best I could ever tell you is it's 50-50. Oh, this isn't going to go to trial. Oh, this isn't going to do that. My favorite is when attorneys tell clients, oh, you know, this isn't going to go to trial. But then you ask them, like, what's your odds of success? And, oh, I can only give you a 50-50 odds. Well, if any attorney's giving you 50-50 odds, oh, because you could either win or lose. That's a false dichotomy. I mean, 50-50 odds, like, if it's a coin flip, if it really is a coin flip, great. But if they're saying that, you know, you're either going to win or lose, and therefore it's 50-50. I mean, I've just seen, attorneys are great with words. Attorneys are great with words. And they will say things that if you're not paying attention, you will think mean that they said something they didn't say. And my favorite one is, well, I'm comfortable with this motion, or I'm comfortable with this cause of action. Well, it's great that you're comfortable with it, but what are my odds of success on it? Do I have good grounds for it? Well, I'm comfortable with it. Well, that doesn't tell me anything. So pay attention to what your attorney says. Listen carefully. If they say something that is unclear, follow up on it. Make sure that you know what they're doing. And finally, I have seen in my comment section so many times, well, what if the cops did this? Would it be a crime if the cops did this? The most recent one is when I was talking about Chile manipulating door handles on vehicles that he didn't have permission to manipulate the door handles on. Well, what if a cop manipulated the door handle? Well, first of all, that's a really vague question. It's really hard to answer stuff like that. But generally speaking, cops have a lot of authority to do things that citizens don't. Cops are authorized to investigate crime. Not just crime that they know is a crime, but potential crime. What's going on here? Is there crime afoot? They also have the community caretaking function where they can investigate things that, oh, there's a car pulled over on the side of the road. I get to stop and investigate what's going on here because there might be somebody who needs my help. Cops have authority vested in them that your average citizen does not. They have been vested with power by the state that the average citizen doesn't have to fulfill their function as police. So trying to say, well, if a citizen couldn't do it, why can a cop do it, is a stupid statement. Oh, if a citizen can't test the handles on police cars, can cops? Well, yeah, they're the fucking police, you idiot. If a cop's out there testing cop door handles, he's probably authorized to do it. In addition, not only do cops have that added power, but there's going to be a presumption that a cop testing door handles is a cop doing one of those functions, and so another cop isn't going to roll up on him and arrest him for it. And you're going to say, well, cops always, they toe the thin blue line, they never do anything. Well, if a cop commits murder, like not on the job where it's a questionable shoot, but like actual murder, and you can watch videos on this, the cops will investigate it, and the cops will make an arrest if there's probable cause. If a cop gets caught driving drunk, the cops will make the arrest. Like, there's countless videos on countless cop body cam channels that document these things, or the interview channels where they're interviewing suspects. And there's countless times where cops have been interviewed. Oh, they're drunk on the job. Boom. There was one I saw where a cop killed a prostitute that he hired and tried to dispose of the body. And then he tried to jam off to Mexico. I mean, there's countless of these videos. But something like a misdemeanor for a citizen is not necessarily a misdemeanor for a cop. Hey, citizens aren't allowed to open carry in this state. Well, cops are. Congratulations. Well, what if a cop was open carry? Yeah, the cops are allowed to. Concealed carry. Most cops are authorized to conceal carry, in most places, even when they're off duty. Some of them are even required to by their job. Oh, what if a cop was concealed carrying? Citizens can't do it. Well, yeah, he's a cop. There is a quantitative difference. Words have meaning, generally speaking. I know that in today's society with propaganda, a lot of words have lost meaning. Who knows what right-wing extremist means? It could mean that you posted something online. It could mean that you blew up a synagogue. Who knows, right? Who knows what right-wing extremist means now? But cop has a definition. You're an employed law enforcement officer authorized by the state or the federal government to enforce state or federal crimes. It has a meaning, right? And citizens aren't federal or state law enforcement officers who are authorized by the state to investigate crimes or prevent crimes or arrest people for crimes. Citizens have a limited, generally speaking, depending on your state, citizens have a limited arrest authority. Cops have a much broader arrest authority as long as they have probable cause. A citizen can't arrest someone for a misdemeanor that wasn't committed in their presence, pretty much in any state. Cops can. There's a difference. Anyway, so it's a silly question that I see a lot of times on anti-cop channels. But it's a silly question because cops are different than citizens. And I hope that makes sense. If that doesn't make sense, I don't know what else to tell you. Again, I can explain it to you. I can't understand it for you. Thanks for watching. Enjoy the sun. Have a great day.